Mr. Shapiro. Mr. Shapiro.
May it please the Court. Good morning, Your Honors. My name is David Shapiro, and I represent the City of Somerville on this appeal. I'll be addressing three key points in my presentation. The first key point is that the comprehensive statute for the MBTA does not preempt local regulation for commercial advertising. My second key point I'll be addressing is that commercial advertising is not reasonably related to the essential governmental function of the MBTA. And the third key point I'll be addressing is that the zoning regulation will not interfere with the legislative mandate of the MBTA to raise revenue. I'm turning now to my first point.
Let me ask you, you're representing Somerville, am I correct?
Yes, Your Honor.
Yeah. The T could put up a smelly, noisy, carcinogenic facility in the town, and they can't put up a billboard?
Your Honor,
Is that essentially what you're saying?
we're actually looking at the ability of the city to regulate these billboards through its zoning ordinance. And,
Well, that is what you're saying.
I'm sorry, Your Honor?
That is what you're saying.
Well, it's the effect under the law.
It's the legal effect under the law of what the MBTA.
I mean, you may be right. There may be no authority to do this.
Right, and that's what the, under the statute for the MBTA. The MBTA does have a comprehensive scheme for their MBTA operations, and in those respects, the MBTA is exempt from local control. For the operations of the MBTA, for the facilities that are used in connection with the MBTA-related facilities, and used in connection with the mass transportation, the MBTA would be exempt. But there's a separate section, an entirely separate paragraph in this statute dealing with commercial advertising.
But what about, I mean, the idea that within the essential governmental function is actions taken in furtherance of it, and raising money seems to be a statutory objective, I mean, of the MBTA to support its operations, so...
That actually leads me to my second principle, that is the case law analysis under the Bourne case. Under the Bourne case, a parking lot was reasonably related to the essential governmental function of the operation because that was helpful, necessary.
Was a parking lot mentioned in the statute specifically?
No, it wasn't, Your Honor.
So the court interpreted that as essentially a function that was essential to the governmental function of running the steamship.
The court determined that it was reasonably related to the essential function of the steamship, and I would submit...
But here we have a statute that says that you have to develop essentially non-transportational funding, and the statute specifically mentions advertising.
I would submit that is a power that the MBTA has, undoubtedly. The MBTA does have the power to engage in commercial advertising. But just because it has that power does not make it automatically reasonably related to the essential governmental functions. If that were the case...
It strikes me that there's something more here. I mean, the directive is to raise money through these other enterprises to ensure, in essence, that the fares remain low, because you can't increase the fares until, in essence, you've done all of these other things to maximize the revenue, so that people will use the transportation system. I mean, that seems a little more related to its essential function than just raising money generally.
We would submit that the revenue-producing function that the MBTA has here through commercial advertising is reasonably related to its fundraising function. But the courts look at the nature of the activity. What is the activity?
It's more than related to its fundraising function. It's really related to part of its core purpose, which is to ensure that public transportation is available to people, that fares remain as low as possible so that that transportation will be used not only for the benefit of the citizens, but also for the benefit of the environment.
That's correct, Your Honor.
That seems a little different to me.
We would suggest, at least under the case law in the Bourne case, that the critical inquiry should be, how does the nature of the activity in question, how does that activity itself improve or benefit or make transportation more effective?
By keeping the fares low.
I'm sorry?
By keeping the fares low.
We believe that the Bourne case stands for the proposition that the activity has to be related to the mission of the MBTA. And the MBTA transportation mission here is, in fact, to provide transportation. So we think there should be a nexus between the activity itself and the mission of the MBTA to provide transportation.
And is there a case that actually uses that word, the nexus?
Well, actually, the Bourne case refers to the reasonable relationship test. And the Bourne case looked at the activity itself, that is parking lot. And the parking lot certainly was helpful to the steamship authority to function. And I would suggest to the court that the relationship here is far too tenuous to be deemed reasonably related to its governmental function. If it were a parking lot, that would be fine. If it were a bench, something that could be used to help improve transportation, that's what the activity.
Why does the bench improve transportation?
A person could be sitting on the bench to help them wait for the tea, for example. That would make more sense to me.
But if,
But
it- but
all we
if-
have here is an advertising sign promoting McDonald's, for example. How does that make transportation itself
Maybe it'll
more
help them
effective?
put another seat on the T car.
or maybe it's going to be less money for Somerville to pay as one of the participating communities.
I guess our submission, Your Honor, is that under the reasonable relationship test set forth in the Bourne case, that the activity itself has to have a closer link than simply raising revenue. Because otherwise, that would effectively give the MBTA absolute immunity for any revenue-producing function. And it renders the Bourne case, the Bourne test meaningless, because otherwise you'd be saying any power of the MBTA is automatically exempt from local zoning. Any revenue-producing power is automatically exempt. And we don't believe that the Bourne case stands for that proposition, Your Honor. There has to be a nexus between the activity we believe and the function of the MBTA.
So if the MBTA set up little kiosks selling coffee and donuts in the morning and all that kind of stuff, or leased it out to Dunkin' Donuts to do, would that be all right?
And I would submit that that would be much closer to the relationship there. But here we simply have
Why?
a sign promoting
Why?
advertising.
Why? What does that have to do with transportation?
I think that would be at least reasonable to state, the MBTA could claim.
Why?
It would be reasonable to state that
You don't need coffee to go on the tea.
it's not
Maybe some
needed,
people
but it actually, I would suggest to Your Honor that in that case, there is some relationship, a reasonable relationship there between a person who is entering the MBTA station and then using that to help them to ride the T.
I'm sorry to interrupt you. You finish.
But leading me to my third point, I see I only have 10 seconds left, but my third point was that that in the alternative, even if this court finds a reasonable relationship between those two activities, that this case, its negligible effect on the impact of the MBTA here, because the MBTA has not even made any effort to comply with our zoning ordinance. May I have another 30 seconds, Your Honor, or I see my time has expired.
All right, 30 seconds.
The key point is that in the alternative, this case could be remanded back to the trial court for determination as to how that mandate is actually interfered with, because the interference with the mandate raises a factual question here, because the MBTA has made no showing that they could still comply with our ordinances and still fulfill their mandate. And Mr. Lucas will be addressing the remaining arguments.
All right, thank you.
Good morning, Your Honors.
Mr. Lucas.
May it please the Court. My name is David Lucas. I represent the City of Melrose. I think we've already discussed whether there is a reasonable relationship, Your Honors, between...
Could I ask you one question? This is
Absolutely.
what I wanted.
Absolutely.
Either of you could answer. Do I understand correctly that if the billboards have on them advertising that is purely public service advertising designed to increase T ridership, you're not troubled by that? You're troubled by the McDonald's ads?
I wouldn't say I'm not troubled by increasing T ridership. I think if it advertises the services of the T itself, then yes, it's reasonably related.
And so you wouldn't have, they could do that?
I don't think Melrose would have an argument in that instance. I don't think Melrose would have
So
an
it's the
argument. I'm
me-
not going
it's
to get
the
into First
message.
Amendment.
No, but I mean, is that it? Is the message what makes the difference?
Absolutely, because if the MBTA is advertising its own services, that probably complies under our zoning.
What if the billboard was divided in half, which some billboards are, and it had, use the MBTA because of this and that on one side and McDonald's on the other?
The billboard still doesn't comply under our zoning, Mr. Justice.
Why?
So, because in this business district in Melrose, where the billboard is set up, the physical aspects of it, you can't have an advertisement there advertising somebody else's services. You can have an advertisement selling the property owner's services. Right there.
Mr. Lucas, Judge Van Gestel also referred to the MBTA's obligation to establish and implement policies that provide for the maximization of non-transportation revenues
Yes.
from all sources. Isn't that exactly what happened here?
I think it's what they're trying to do, Your Honor, but the record isn't really clear of what revenue they're producing here in Melrose at those signs at that Cedar Park station. Now, if you're suggesting, Justice Ireland, that that creates the reasonable relationship, I agree with Mr. Shapiro. I think the court has to go beyond that and simply not look within the statute to see if the MBTA is empowered to advertise, and that's as specific as it gets. The court should understand. There's nowhere in the statute does it say the MBTA may erect billboards. It doesn't say they may advertise with signs. It just says that they may contract for advertising upon their property. Now, we might expect reasonably that that includes some kind of written advertisements. The MBTA has been doing it for a long time. But I don't think the fact that that's all that's mentioned in the statute creates that nexus, and that is our word, Mr. Justice. I don't know of a case where the word nexus is used, but it seems like this court did that in Bourne v. Plant. They looked at the actual proposed use of the land or structure rather than just seeing if there was some authority, general authority to do that, although the Bourne v. Plant court also looked at the statute with respect to the Nantucket Steamship Authority. Now, let me say this. Even if this court finds that there is a reasonable relationship, Mr. Shapiro started to talk about this, I truly believe under Greater Lawrence Sanitary District, the zoning ordinance in Melrose to these 3 billboards still must apply. In that case, this court suggested that so long as those local regulations have nothing more than a negligible effect, there's no reason why the local regulation would apply.
But in this case, if you apply the Somerville and Melrose regulations, there will be no advertising on these 2 sites, correct?
I don't think that's true, Your Honor. I think there are several options. Let me just speak with respect to Melrose, the ordinance that I'm familiar with. I think there are several other options.
I thought there was a stipulation that would be that under your regulation, under your zoning ordinance, what the T wants to do or Clear Channel wants to do couldn't happen.
Absolutely. With the T and what well, it's not Clear Channel in Melrose. It's, I believe, Titan Outdoor Inc., but
Titan,
correct.
Right.
What the T wants to do in Melrose that are there right now, those could not happen. They have 3 big billboards right at the very corner, almost on the public way of their property. They couldn't do those. But there are many other advertising options they could do within the station. Inside their interior structures, where people sit, there are several options that probably the building commissioner Melrose would not be authorized to say you have to get rid of that. So we're not suggesting, this is exactly why I say there is nothing more than a negligible effect if these 3 billboards in Melrose are removed. Now,
I'm sorry, maybe I'm misunderstanding. You're saying, well, they could put signs inside the station. Have you even considered the different revenue streams that would, I mean, the whole point here is you're using this property to advertise to a very wide, not only users, but people who don't use.
I have considered that, Your Honor, and I don't think there's anything in the record that would suggest what revenue they're even getting at Melrose. Now, you and I can reasonably assume that probably a giant billboard that is right at with no front yard setback, right on the edge of a public way, probably generates more, has more visibility than something with people sitting at the T. I suppose I can reasonably assume that, but there's nothing in the record to suggest that. The only facts in the record, which they're in the agreed facts, but the MBTA argues it in its brief, is that Melrose, which includes these 3 signs, their advertising program, of which Melrose is only a small part, I believe generates $750,000 per year. Now, that's a nice chunk of change. I could use it, certainly. But we don't know how much Melrose is producing. We only know that that is part of a large contract. So there's nothing in the record to even suggest what the dollar value of the loss might be. And second, there's nothing in the record to suggest how much that dollar loss would be mitigated if the MBTA advertises in a different manner that does comply with our zoning. I don't know if this court wants to get into putting a dollar amount on whether something is a negligible effect upon the operations of the MBTA. That might be a pretty slippery slope to go by. But the fact is there's nothing in the record to suggest that there will be anything more than a negligible effect on the MBTA's operations if these 3 signs, that's all we're talking about here, These 3 signs in Melrose are removed. We don't have any other ordinances in the record other than Somerville and Melrose. What's interesting about the Greater Lawrence Sanitary District case was that was a situation where the town of North Andover was actually seeking to regulate the building and construction of a principal structure, which is the exact purpose of the Greater Lawrence Sanitary District. The district, I'm sure this court knows, the district was trying to put up a sludge treatment facility, and yet local health regulation was still applied to the building of it. The parallel of that to this case would be as if Melrose were trying to regulate the building of the T station itself, not just the commercial advertising billboards. So if in that case a local ordinance could apply, certainly in this case a local ordinance should apply to those 3 billboards. And to answer the question that was asked previously, what if they put up how can they put up a smelly station that pollutes? Unfortunately, I don't know if I have much argument with that. I think they could.
Thank you.
Thank you, Mr. Justice.
Mr. Davis?
May it please the Court, I'm Brian Davis, representing the MBTA. Actually, Your Honor, first, the issue in this case, it could be resolved just on the face of the MBTA's enabling statute, which is Chapter 161A, because the cities concede in their briefs that facilities of the MBTA are exempt from local control. That's conceded on page 16 of Somerville's brief and 26 of Melrose's brief. So their only counterpoint to that argument is that these signs do not constitute part of the facilities of the MBTA, and that is in fact wrong. I mean, it is conceded, it was stipulated by the parties that both the Somerville facility and the Melrose Cedar Park station are facilities of the MBTA. And the definition in Chapter 161, Section 1 of facilities includes structures that are pertinent to those facilities. It includes improvements on those facilities. So it would include these signs, which are improvements, structures on the facilities. That's the end of the story, with all due respect, because the statute makes it absolutely clear that the legislature intended MBTA facilities to be exempt from local control.
What do you say about the suggestion, could you open a kiosk selling coffee and donuts?
Yes. In fact, the MBTA does that. Those kiosks exist. There are coffee and donut facilities in MBTA stations. You know, the issue arose also in the down below. The suggestion was IKEA. Could the MBTA open an IKEA and raise money that way? And the answer is, if it's in the statute, as commercial advertising is, if it said the MBTA can operate IKEAs, okay, and it was
Would that be then become a facility of the MBTA if in the parking lot of one of the stations you put up a completely unrelated commercial enterprise and say, well, that's an MBTA facility, nothing to do with transportation, but comes within the statute?
The analogous situation, Your Honor, here would be that the MBTA's enabling statute said that the MBTA could operate an IKEA and that the MBTA was expected to maximize revenue from the IKEA. And if that was the case, I would be arguing that it was authorized by the statute, that it was reasonably related to the MBTA's governmental function.
The way they're losing money now, they may allow them to put a casino in there.
That possibility was raised as well, Your Honor. And the point of the matter,
machines.
the MBTA, there's nothing vindictive or spiteful about what the MBTA is doing here. It's doing exactly what it
Now,
has been
there is an
instructed to do.
advertising provision in the statute, is there not?
Yes.
And would that cover this also?
Yeah.
If we have to descend to specifics rather than the general statute?
If we descend to specifics, Your Honor, it does cover it. I mean, it permits because it specifically authorizes the MBTA to sell and
contract for
lease
advertising.
commercial advertising in and on its facilities. Not just in,
But
but on the facilities. Okay, that's explicit in the statute, and that has happened for decades, and that's also stipulated by the parties. So that what the activity, the general activity that's going on here, has been engaged in by the MBTA for fundraising purposes for decades. And the MBTA has been instructed, as of 2000, by the legislature to maximize that revenue stream.
Is there anything in the record of this case whether this issue has arisen in other communities?
There's nothing, Your Honor, in the record. But I can tell you that I think this issue, it's not just the Melrose Signs. It is in the record that this is part of a broader program that touches upon many, for example, the Titan program touches upon many commuter rail stops.
How long has the billboard been there?
The billboard in the Melrose facility, Your Honor, I think was erected in 2006.
So is that the older of the two?
It is, those are the only signs that actually have been erected. The
Okay.
proposed signs in Somerville have not yet been erected.
I think I know the answer, but your brother referred to the siting of the sludge facility. Why doesn't that govern this case?
I think the reference, Your Honor, was to the fact that the location of the Somerville signs is in a commercial district that is, in fact, authorized for abattoirs, auto salvage, and other noxious uses. And so the placement of the signs there doesn't seem to be any worse than any of those others, and I would argue was considerably less noxious than the others. I mean, the truth of the matter here is that the programs that we're talking about, both in the commuter rail stations, there are signs in commuter rail stations more than there used to be. MBTA is maximizing that stream of revenue. The signs in Somerville are not signs in the middle of Davis Square. Okay? They're signs in an industrial area adjacent to I-93. These will not be the first billboards ever constructed on I-93. Okay? They will be the same size as other billboards that already exist on I-93. They will generate revenue for the MBTA. They'll generate hundreds of thousands of dollars annually for the MBTA, which is desperately needed. It is correct that the amount of revenue from the Melrose signs alone was not parsed out in the record below, but it was part of the record that program in the commuter rail stops generates approximately $750,000 for the MBTA right now, which is also desperately needed. And again, all in accordance with the legislature's instructions.
But what about the Greater Lawrence case, though? I mean, to the extent that local regulation won't burden the ability to fulfill a legislatively mandated function, why shouldn't the MBTA at least comply with local regulations? How would this substantially burden you?
There are two lines of analysis here, Your Honor. The Greater Lawrence case did not include an express legislative exemption from local control. So Greater Lawrence, I would argue, does not apply in these circumstances where the legislature has expressly stated that MBTA facilities will be exempt from local control. Putting that to one side, if you're dealing solely with the question of whether it's reasonably related to the MBTA's governmental function, then in those circumstances, in the Greater Lawrence Sanitary District case, first of all, they were not zoning regulations. They were public health and safety ordinances issued by the Board of Health. That's a different category. Okay, and I would seriously question whether this court would have decided the Greater Lawrence Sanitary District case in the same manner if what the town of Andover, North Andover, had been complaining about was the appearance, okay, not dust, not blasting, not odor from that facility.
Let's assume that we don't agree with you that the exemption for MBTA facilities covers outdoor advertising signs having no practical or functional relationship to the operation of the transportation facilities. You say Greater Lawrence still wouldn't apply.
Still wouldn't apply, Your Honor. It's again, the Greater Lawrence Sanitary District case is quite explicit that what the court was dealing with there were limited anti-nuisance regulations. And the type of zoning regulations that we're dealing with here are focused solely on aesthetics, and again, that's a different animal. And the negligible effect, I think the court put its finger on it, that this is not negligible. It is both Somerville and Melrose's intent to eradicate these signs. And you heard that as well. The signs that Mr. Lucas was discussing that would be permitted in Melrose would be signs inside the building, not signs on the platform. The signs of the platform are a different program. That's the Titan program that's referred to in the stipulation of facts. Okay, that's a separate revenue stream. Again, unfortunately, desperately needed by the MBTA right now, and engaged in and enacted in accordance with the MBTA's directive from the legislature to maximize its revenue stream, all non-transportation revenue from all other sources.
I wondered whether you put that article in the paper just before this case.
Right.
I absolutely innocent, Your Honor. I saw it myself yesterday, and the answer is actually this has been in the news quite a bit lately. So that's one article in a series of articles that have appeared in the last few months.
Can I ask you this? Let's going back to the definition of facilities that are exempt. Am I right? Is this facilities as defined in Section 1?
Yes.
it talks about all property, land improvements, et cetera.
Correct.
Used in connection with the mass movement of persons. Is that a qualifier on all of these descriptions?
It's a qualifier, Your Honor, on the facilities. So the facilities have to be used in connection with the mass movement of people. And
And certainly advertising boards are not used in outdoor advertising is not used in connection with the movement of persons, is it?
No, that's correct, Your Honor. I mean, they don't move people, but the facilities that they're part of, that they're pertinent to, are used in connection with the mass movement of people. I mean, certainly the Cedar Park Station, that's exactly what it does. The Somerville facility, it's used, the definition of facilities specifically includes garages, yards, and shops. The legislature understood that there are back office facilities that the MBTA has as well that would fall within the scope of the statute that also are exempt from local control. And that's exactly what the Somerville facility is. It's a facility where they maintain the equipment, they repair the engines. You can see it, it's huge. It's immediately adjacent to I-93. So again, it falls clearly within the definition of facilities as defined by the legislature.
Thank you.
Thank you, Your Honor.
Ms. Alvarez?
Good morning, Your Honors. May it please the Court, Ida Alvarez, Assistant Attorney General on behalf of the Outdoor Advertising Board. The Superior Court here properly affirmed the Board's decision to issue the permits to clear channel to erect the advertising signs in the town of Somerville based on the Essential Governmental Functions Doctrine, which in turn was informed by the statutory scheme of the MBTA and the case law that this Court has developed under that doctrine. As it was discussed earlier by Mr. Davis, the MBTA statute is pretty comprehensive and includes an explicit provision providing that the MBTA has the power to sell, contract, or lease for advertising in its facilities. In connection with that, the MBTA also has is mandated by the legislature to engage in revenue-producing activities in order to maximize its non-transportation revenue. And in conjunction with those two statutory provisions, as well as other budgetary provisions in the MBTA statute, the Board concluded that the advertising billboards, the function of raising revenue through that was reasonably related to the essential governmental function of the MBTA, which is to provide mass transportation services to the citizens that it serves in the communities it serves. In addition to that, I did want to mention that the Board relied on the Greater Lawrence case, which was the most recent case by this Court on this issue of the essential governmental function doctrine. And unlike the anti-nuisance regulations in that case that were held to be applicable, the zoning here is not like the regulation of dust, noise, odor, or any kind of health-related concern. The zoning regulations here are, as stipulated in the agreed statement of facts in the Superior Court, would be completely eradicated by the zoning ordinances. So it's not an issue of it being related to anti-nuisance types issues, and secondly, it's not really a negligible effect, as the advertisements would not be able to be erected at those locations.
Well, what if the zoning regulations simply required a somewhat smaller sign, or certain color limitations, so that they weren't so dramatically offensive in visual sense?
Your Honor, that was not a question that was presented to the Board. I would think that it would depend on the language of the ordinances of the cities, but it seems to me that if the size were smaller or the color was different, the only evidence that was presented below at the Superior Court that was concerning to the cities was the fact that the signs were not representative of the scheme of the other surrounding area of the advertisements. There was no other concern articulated about the signs as to what would prevent them from complying from the ordinance.
The only point I was trying to get at, I was trying to understand your argument that I can understand it if, in fact, the zoning regulation would not permit the signs to go up. That seems like a pretty significant interference with the MBTA's functions. But if it was simply that they had to either be positioned somewhat different so they weren't facing a residential section or something of that sort, something more modest and more directly related to sort of people's interaction with them or potentially offensive interactions with them, would that be okay?
That may be different. However, that was not what was stipulated below in the record here as agreed in the statement of facts before the
Yeah,
Superior Court.
that's not before us, thank you.
Thank you, Your Honor.